All right, welcome everyone. Today's webinar is for those who are married and have large estates. And if you're worried about the exemption going down in 2 years, then this topic is for you.
Yeah, welcome everyone. I'm Jared Hames and this is Christina Hess. She has been practicing law for 24 years. She graduated UC Berkeley Law and she's a certified specialist in trust, probate, and estate planning.
Yes, awesome. Thank you, Jared. And just our disclaimer before we get started today, this is for educational purposes only. This is not legal advice. And unless you've assigned an attorney-client agreement for this particular area, I might be your lawyer for other purposes, but that's our disclaimer. All right, so we're going to dive right into today's topic. And
Yeah, so the first question I have is what is a SLAT, just for the people who don't know what a SLAT is?
yeah, so a SLAT, or otherwise known as a Spousal Lifetime Access Trust, it's an irrevocable trust that one spouse sets up for the benefit of the other spouse for his or her lifetime. So basically, one spouse is taking their current lifetime gift exemption, which in 2023 is $12.92 million. So you could gift up to almost $13 million tax free. So if you haven't done any prior gifting, the government says you can either give away your money while you're alive up to a certain point that's tax free, or you can give it away when you're gone. But the big difference is that the exemption right now is really high. It's Trump in 2018 passed the American Taxpayer Relief Act, and it's $10 million per person adjusted for inflation. And it's going to sunset in 2 years. So in 2 years, on December 31st of 2025, that number is going to be cut in half. It's going to be $5 million per person. So a lot of people are like, if you are married and you have over $15 million, what do you do? How can you leverage this really high exemption before it goes away? Because Jared, if we were to survey CPAs, financial advisors, trust attorneys, and you said, what do you think? Do you think that the government's going to let the exemption sunset in 2025 and go down to 5 million? What do you think most people's answer is?
No.
Yeah, no, most people, like 9 out of 10 people, this is not an official survey, but most people think, yeah, the government's going to do nothing. So, no, yeah, no, they're not going to do anything.
Yeah.
Yeah, they're going to let it go down to $5 million because we have a massive amount of debt. And, it's possible Congress could always change it. But right now, we're set to go from 13 million to 5 or 6. It'll be adjusted for inflation, so it'll probably be 6. We don't know what it'll be, but it'll be probably over 6 million per person. So there's an opportunity, there's a window of opportunity for spouses now, if you're not married and you're like, I love this strategy, but I don't have a spouse, I mean, you don't have to go get one. You could still use this strategy, but it doesn't work quite as well. The benefit of this for married people is you're giving the money away, but you're giving it to your spouse. So in essence, you can still have access to it. That's why it's called the Spousal Lifetime Access Trust, because you're giving it to them, but you're married to them. So you're really still, it's kind of like you can have your cake and eat it too. But it moves the assets out of your taxable estate. And then if the trust is structured properly, it's going to be out of the taxable estate of the spouse as well.
Wow. So that's a huge jump from 13 million to 5 million. I mean, that'd be a very significant jump.
Yes,
So,
and the marginal tax rate for people who are every dollar over your exemption, the government takes 40%, and they could change that. So almost half of every dollar over is going to go to the government. So that's why for people, this is a window of opportunity to use your lifetime gift exemption before it goes away.
wow, wow. So next question I have is who does this benefit exactly? Like who exactly is this for?
Yeah, so I think this is a great strategy for people who are married, and the sweet spot, I would say, is you want to have assets over $15 million because If you could still use it if you have less than that, but in order for it to be efficient, so if you're going to have $6 million of exemption in 2 years, and if you don't use at least 6 million now, then it doesn't really make sense, because what's going to happen is, let's say, in this picture, let's say husband is going to gift us do a SLAT. Let's just do a case study. So Sam is the husband, and he's going to gift, let's say, $9 million to a SLAT for his wife. So he's going to use up 9 million of his 12.92 million, and he's going to gift those assets into a SLAT for the benefit of his wife. Now he's going to file a gift tax return, and he's going to say, I used 9 million of my almost 13 million. So he's got 4 million left. But if in 2 years that number sunsets, he's only going to have 6 million. And let's say he dies the next year. So he dies, he used 9. In the year of his death, let's say the exemption was 6. So he's going to have 0 exemption available at death. But had he not done the SLAT, $3 million would have been taxed at 40%. So
Wow.
he's saving, the estate is saving 1.2 million plus any appreciation. If that 9 million appreciated over those 3 years, you're saving 1.2 million plus any gain in the assets over those 3 years. So that's a good example of how it works. So who does this benefit? It benefits Sam. Obviously, it benefits his wife. If she survives him, she's going to continue to be a beneficiary of this trust for the rest of her life. And if Sam had lived, he would still get the benefit of the SLAT during his lifetime as well. He just used up his estate exemption before it's cut in half in 2 years. So it's a really great strategy, and it could really help save a lot of estate taxes if in fact in 2 years this number sunsets.
Wow, that is a huge, yeah, it's a huge, huge jump there. It's a lot of vacations to Hawaii.
Yeah.
So,
Yes, a lot of vacations to Hawaii. $1.2 million worth of tax savings in it, and it could be more.
wow. Wow, so the next thing is, what are some things to watch out for? Are there any downsides, any things to worry about?
Well, so two things to watch out for. And the reason that we're talking about this in 2023, when we still have 2 years until the exemption goes down, is some spouses might be saying, okay, well, that's great. I do a SLAT for my spouse, but she should do a SLAT for me too, right? It's only fair. If I'm going to give her 9 million, then she should give me 9 million back. And you can do that, but the problem is the IRS, there's been lots of cases, and the problem is you cannot, there's a reciprocal trust doctrine. So the reciprocal trust doctrine says if you do an identical trust over here, for husband does it for wife, and then wife does an identical trust, irrevocable trust over here, the IRS is going to say that violates the reciprocal trust doctrine. We're going to void the transaction, and all the assets are going to claw back into your estate. So the trusts have to be different, and then they need to be done at different times. So for a lot of people last year, this year, we're doing the first spousal trust. So we're doing one set of gifting, but then the other spouse is not going to do the gifting until 2025. So we want time and space in between the transactions so that we don't violate the reciprocal trust doctrine, and we don't violate the step transaction doctrine. The step transaction doctrine, there's been several cases. I'll just give you one case where a husband gifted his business to his wife, and 2 days later she turned around and put it into the trust for the kids. They collapsed the gift to the wife, and they said husband was the donors, and the assets stayed in his taxable estate. So you can't do the steps in close sequence in time, because then the IRS, the risk is that they could collapse the transaction. So this has to be part of a larger comprehensive plan. Maybe one trust is going to be a Nevada trust. Maybe we'll have the kids and the spouses as beneficiaries. We're going to have 1 to 2 years in between the transactions. So those are some of the things that you really have to be careful. You can't just, that's why we're talking about it now, because if people wait till the fall of 2025 and they're like, oh my gosh, the exemption's going down in 2 months, what can we do? We'll be like, well, you could do one of these trusts, but it's too late. You won't be able to do both. So that's why we're talking about it now, because we're encouraging our clients who this is a good fit for, hey, let's do the first spousal trust this year, and then we'll plan for doing a follow-up trust that's different in a couple of years.
Wow, 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 wow. Really good, really good.
Yeah, it's a great strategy.
Are there any more other risks that we have to worry about with doing this SLAT?
Yeah, so I mean, the benefits are pretty obvious. You're saving estate taxes, you're still getting the benefit of the assets as long as your spouse lives. But let's go back to our example, and Sam gives $9 million dollars to his wife. We'll just call her Julie. And then what happens if they get divorced? And then so one risk is Sam did his trust for Julie, but they got divorced before Julie got to do a trust for Sam. So Sam's kind of out $9 million. dollars. And then if Julie didn't do corresponding gifting, that could be a huge risk. And we can't really have like an agreement that says, okay, you're going to turn around and do this as well, because that would, look bad if we were ever audited. So we really have to make sure this is a clean transaction. So that's a huge risk. There has to be sort of some reciprocity without violating the reciprocal trust doctrine, right? So divorce is a risk. Now, in the trust itself, like let's say Julie does a trust for Sam, let's say they each had done trusts for each other and then they decided to get divorced. The trust can say the spouse can continue as a beneficiary even if they're not a spouse. So that can be dealt with. The other thing is what happens if the spouse dies, right? So let's say Sam does a trust for Julie, Julie dies. Then what? Sam no longer has access to the money through Julie because she's dead. So then it's going to either go to the kids or the other beneficiaries. So if he needed access to the money, he would have to get either the trust protector or someone, to give him access, or he'd have to get access if he needed access through the kids, or he could always get a loan from the trust. That's a possibility. So there's still ways for him to get access, but it's not as seamless as when you're just getting access through your spouse. So death is a risk. And then the other thing with gifting is taxes, right? So we're utilizing and we're avoiding estate tax, but we also have capital gains tax. So when you do a gift, the cost basis in your asset is a carryover basis. So let's say of that $9 million dollars that Sam gifted to Julie, let's say some of it was real estate or some of it was stocks and bonds. The basis in the asset is going to be Sam's cost basis. So when he purchased it. So if he bought a house for $1 million and now it's worth 3 and he transfers it to the irrevocable trust, it's a completed gift. So the cost basis is going to be 1 million, not 3 million. So you do lose the step up in cost basis. So if those assets were sold, there would be capital gains tax. So that's something to keep in mind. Now, there are ways to plan around some of these downsides, which and a couple of them I've already mentioned, but I think people just need to be aware of what some of the risks are and just know that most of them we can deal with through the drafting. So for example, you can give um, the trust can have the power to substitute assets. So maybe you have a high capital gain asset within the trust. We could actually swap out cash for that asset. So there's things that we can do to give you added flexibility, but there are some inherent risks that people should be aware of.
Wow, a lot of really good information.
Yes. So one other thing that I wanted to mention, and then we'll open it up for any questions. But one other thing I wanted to mention is in California, so we're in California, there's 9 community property states. So people might be saying, well, how does Sam gift money to Julie? Because everything that we have is community property. So that 9 million, half of it's actually Julie's. So what we have to do in California is before Sam gifts any assets, unless he has separate property like that he had prior to marriage or that he inherited, then he wouldn't have to do this. But anything that's community property, before we can do these transactions, we have to transmute the community property to separate property. So we have to divide the estate into Sam's separate property and Julie's separate property. So that needs to happen in advance. That's just one additional caveat that I wanted to mention.
Really good info. And yeah, we'll just open it up if there's anyone who has any questions. If you could just type it in the chat, just and we'll give it a minute or two if anyone has anything they want to ask Christina.
Yeah, and just to summarize what we talked about today while we're opening it up, if anyone has any questions, just to summarize, the Spousal Lifetime Access Trust is advanced planning. It's an irrevocable trust for the benefit of your spouse and potentially children or other beneficiaries. And it allows you to gift and use your lifetime gift exemption now while it's high before it's cut in half in 2 years. So if there's no questions, we're going to go ahead and end the webinar for today. This one was short and sweet, but hopefully you got some good information. And my contact information is here, and we look forward to hearing from you in the future.
Awesome. Thank you for all that info.
All right, Jared, thanks for joining me today. Everyone
Of
have a great
course.
day. Yeah, and we'll see you soon.